Good evening, everyone. Thank you so much for joining us for this month's webinar on guardianship and alternative options for decision making. I would like to welcome attorney Victoria Davis Davila, who graduated from Marquette University Law School in 2011 with her Juris Doctorate. She has dedicated her legal career to supporting individuals with disabilities and their families regarding guardianship and decision making, special education law, estate planning, obtaining services for high needs children, civil rights, family, and juvenile issues. In 2019, she and her mentor, attorney Rock Playdell, formed Davis and Playdell SC, focusing on disability and civil rights and practicing throughout Wisconsin on state and federal issues. Her passion for this area of law was inspired by her younger brother and is furthered by being a parent of a child with special needs. She lives in Milwaukee with her husband and two daughters. Thank you, Victoria, for joining us.
Thank you so much for having me. I am going to just get my screen share set up here. Today we're going to be talking about guardianship and supported decision making and kind of the spectrum of options in between. And if you have questions along the way, put them in the chat box. Katie will let me know what they are. And here we go. So I call this a walkthrough guide. We're certainly not going to get into, super specific details. If you ask questions, try to keep it general enough so that, I guess you're not sharing anything too confidential about your family situation or something that you would want to, keep privileged between you and an attorney. So Katie already did my introduction, so I won't add a whole lot to that, but I will say that supporting families, especially at the transition age, is one of my passions. The transition from childhood to adulthood is not easy for any child, but when you have a child with special needs and you're trying to get out of the children's silos into the adult silos, it's so much all at one time. And so this is an area that I am really passionate about. Today we're going to learn about the different options for decision making, the functions of the tools that are out there, and kind of what the criteria are for using each of them. So when is the right time to start thinking about decision making? First of all, it's never too early, but when you start to plan for a transition through the IEP process, which is at age 14, it's a really good time to start having these discussions, because one of the considerations for decision making is whether the person would be able to make decisions in their own best interests given education, training, or support. While you want to start that education, training, and support when, early, and not wait till they're 18 and say, oh, hey, we got here and now this person can't vote independently or can't make healthcare decisions independently. We want to start that early. Pay attention to how your child is transitioning to adulthood. At age 17, so right around the 17th birthday, consult with a psychologist, a psychiatrist, a GP, a doctor, any MD who knows your child well, and ask some of these questions. Powers of attorney and supported decision-making agreements have to be executed, or can't be executed, I should say, before the person turns 18. Guardianship, for whatever reason, can be granted at 17 and 9 months. So if guardianship is the direction you think you might be going, you can have your court hearing on the day that the person turns 17 and 9 months. So what happens at 18? Lots of rights transfer from the person's parents to them. They can make all decisions, including whether or not to continue in school or to continue in special education. giving consent to medical treatment, choosing providers, choosing a course of treatment, signing contracts, applying for all kinds, different licenses, and applying for loans or credit cards. And these are just some examples, but there is nothing stopping an individual automatically when they turn 18 from all of these rights and powers being vested in them. That only happens if some action is taken. So I think anytime we're talking about decision making, it's important to discuss what does an informed decision actually mean. So there are several components to it. One is you need to be able to understand the information needed to make the decision, understand the outcomes and consequences, have a method of expressing it. So it doesn't have to be a traditional method, but you do have to be able to communicate it in a way that others can understand. An informed decision does not mean a perfect decision the first time or every single time. It just means that, it was made with an understanding of the information and the consequences. So the spectrum of decision making kind of starts on one end with informal supported decision making, so outside of a formal agreement. Then there are formal SDM or supported decision making agreements under Chapter 52. Then kind of in the middle are powers of attorney for healthcare and finances. However, powers of attorney can be complementary to both guardianship and supported decision-making agreements. So in some ways, it's not necessarily a lateral move on the spectrum here. And then finally, there's guardianship of person and estate, and that guardianship can be full or limited. So informal supported decision-making is something that anybody can do. You don't need to have a disability to take advantage of these kind of things. For example, joint checking or dual signature checking accounts, bringing somebody along to appointments, signing release authorizations so that people can have access to medical or educational or whatever records that you see fit. These are all things that can be done without an attorney, without any regard to any special needs whatsoever. They can be usually, undone at any time, and can be really helpful for a lot of people. Supported decision-making agreements became law in Wisconsin in 2018. So it's still a relatively new vehicle for decision making here. And to be honest, they're not nearly as widely used as some of the other options. I think people are starting to get more familiar with them as time goes on. The law was passed with the involvement of lots of advocacy groups, which is really great because one of the disability movement slogans is "nothing about us without us." And I think the whole law reflects that this was done by the people who are going to be using these agreements to improve their lives. A person with a functional impairment, that's the definition, can use a supported decision-making agreement. And that is basically anything that limits at least one major life activity. So an example that I have is I had a client who had a mouth cancer from tobacco use, and he chose to communicate verbally, but it was very difficult for people who didn't know him to understand him. So he had a friend as his supporter who understood him and could kind of, speak on his behalf. He had absolutely no cognitive or mental health or, those type of impairments whatsoever, nothing impeding his ability to make decisions. He was just using the supported decision-making agreement to name that supporter, so it was clear to everyone, like, hey, I've nominated this person to be kind of my spokesperson, and that worked really well for him. Supported decision-making agreements cover a broad range of decisions, and they're different from guardianship or powers of attorney in that regard. So some things are, what you would expect: healthcare and mental health decisions, receiving social services, managing finances, getting public benefits. But they also cover things like finding, employment, finding a place to live, finding food and, obtaining food and shelter. Those things are, guardianship and powers of attorney are generally silent on those. The creator of the document has to specify what decisions can be made. So if it's not clearly indicated, hey, I want my supporter to help me make decisions about medical, then that person is not the supporter for that. And if it's silent, the implication is that the answer is no. So it's only authority that's expressly given by the creator. Somebody is not limited to how many agreements they could have. They could have multiple agreements naming multiple people. They could have one agreement naming multiple people. You can have multiple supporters, and that makes sense because you might have different people in your life who you want to help you with finances versus healthcare versus social services, etc. Anybody can be named as a supporter, as long as they don't have a history of abuse or neglect, either criminally or through county social services departments. The supporter is not a decision maker on behalf of the creator. So at all points, the creator is making their own decisions. The supporter can't do anything without the individual there, or without the creator. They, would have to be together. They can't sign legal documents. They can't legally bind the creator in any way. The fact that somebody has a supported decision-making agreement doesn't require them to have their supporter there or give consent to any decisions that they're making. They can still act independently. And the existence of one of these agreements also can't be used as evidence that a person is incompetent. If someone files a guardianship, you can't say, oh, look, so-and-so had a supported decision-making agreement. That means they were aware that they weren't capable of making good decisions. You can't use it that way. So when we think earlier to talking about what does an informed decision comprise of, the role of the supporter can comprise all of those elements of informed decision making, from gathering the information, including the records, understanding the information obtained, helping the person understand the consequences, and responsibilities and all of the different outcomes, I guess, of certain decisions, and then finally actually communicating that decision to other people. In order to use this tool, the creation of the document has to be knowing and voluntary. So voluntary means you're choosing to do it. Nobody's forcing you to do it. It's your own decision. And knowing means you understand the purpose of the document, the effect of it. So there would have to be at least a basic ability to communicate, hey, this is what I'm doing. This is why I'm choosing to do it. This is why I've chosen the person I have as my supporter, etc. There can be a specified end date to supported decision-making agreements. We can say this is valid for a year. The creator can revoke it at any time by either destroying it or writing a revocation, verbal revocation. The supporter can also resign by giving notice. And there are also certain situations in which it would terminate automatically, namely if there are substantiated claims of abuse or neglect or criminal charges or convictions, I should say, or individual at risk injunctions or restraining orders against the supporter. And that's not just against the creator, it's against anybody that disqualifies someone from being a supporter. So before we move into powers of attorney, does anybody have questions about supported decision-making agreement?
So, Victoria, just correct me if I'm wrong. It kind of sounds like the supported decision maker really has no legal rights.
The
They're just
supporter,
there to help communicate what the individual wants.
right, or to help them understand the decision that they're making, I guess to make clear. So let's say in the context of a healthcare provider, the supporter, by showing the supported decision-making agreement, would be communicating like, hey, I've been designated as a person to be here and help. They would still have to have like HIPAA releases signed, so the supported decision-making agreement doesn't, get rid of that need. And they wouldn't be able to make a decision that the creator didn't agree with. They wouldn't be able to do it without them. It's really just giving you, I would call it in a way, giving you a seat at the table and making clear that, you have been authorized to be involved in this person's decision making without taking over the decision making, if that makes sense.
Yep, absolutely. Thank you.
Sure. Okay, so moving on to powers of attorney. Everyone who is on this call who's over 18 should have powers of attorney. Disability is the only protected class that anybody can join at any time. It is a gift to your family and the people you care about to have these documents in order to make it so decisions can be made for you in the event you're not able to make them for yourself. So when asking, considering whether a power of attorney is appropriate, a lot of times I hear families when they're talking about options, say, look, I don't want guardianship for my child. I'm going to do powers of attorney, and I'm going to have a new healthcare power of attorney, and then I'm going to have it activated the next day. And it's like, well, that's not really, how it works. So the person needs to be able to understand that they either need help or want help with important decisions, be willing to accept the help, share some decision-making power, and most importantly, understand the gravity of what this document is and what it does. And, again, a basic understanding of what it means to execute a power of attorney. So financial power of attorneys are often effective immediately. They don't have to be. Sometimes they're effective based on a contingency, like the person losing their ability to make decisions. And they last until death or until they're revoked or some specified date in the future. Unless otherwise specified, a financial power of attorney is durable, meaning it is still valid even if the person becomes incapacitated, becomes unable to make decisions. So that's why you hear the term durable power of attorney used as well. They are created to allow for another person to manage finances and property, but also just in terms of entering into contracts, dealing with financial institutions, dealing with digital property. I mean, they're really expansive in what they can do. Creation has to be voluntary. They can also be rescinded at any time, even if the person has lost capacity. The creator is called the principal. The person who receives the decision-making power is called the agent. The person creating the document has to be able to select an agent, understand their financial picture, so what are their income and assets and obligations and all that, and understand the powers that they're transferring. So if you have someone, signing a power of attorney, but they're not able to communicate any of those things, there could be a question to whether that document was executed validly. Was it knowing, was it voluntary? So some of the disadvantages, and I'm doing air quotes because there are, reasonable minds can differ whether these are disadvantages or not. So they can be revoked at any time. So in the sense of it could be a problem for someone who when they need it the most, need help the most, might revoke it, and then there's no decision maker, and then we're in trouble. There is no court oversight, which means there is a potential for someone to be financially exploited under a power of attorney. Happens all the time. It's not always accepted by banks for various reasons, including that they don't feel the person had the capacity to do the document to begin with, and the validity can be challenged. So that's a good thing, but also I think in the context of working with people with disabilities, I think it can be kind of a bad thing because so many people presume incompetence versus the opposite. And I see many issues where people are not accepting that a person entered into a power of attorney knowingly or voluntarily. Some other financial management options include conservatorship. So that's where there is court oversight. It's voluntary on the part of the person, the conservatee. They're not found incompetent, but it gives power to the conservator, the same as a guardian of the estate, to manage the person's finances. There are also trusts where a trustee manages funds, has to act loyally to the beneficiary, and there are even special needs trusts which allow people to maintain their Medicaid eligibility and Social Security eligibility. And there are also ABLE accounts, which are, again, bank accounts, which also allow people to save money, keep their benefits, and do not require a guardian in order to take advantage of those accounts. For people whose only income is going to be Social Security, that can be managed by a representative payee who uses the funds for the support and maintenance of the person, and they do have responsibilities to Social Security to comply with their reporting requirements.
Victoria, just before we move on to healthcare, I guess why would someone select a financial power of attorney over representative payee?
It wouldn't be over, it would be in addition to. So anybody, well, okay, not anybody who receives Social Security has a rep payee. Many people just receive their benefit outright and manage it themselves. A rep payee would be if you can't manage your own funds for whatever reason. And you can have a rep payee without having a financial power of attorney, and vice versa. For somebody who is able to, needs a rep payee, but also has the capacity to have a financial power of attorney, I would recommend both. So because there's more than just, managing the money in the account, there are so many other decisions that have to be made, that being rep payee doesn't really help you do anything besides receive and manage the Social Security funds.
Got it. Thank you.
Sure. So moving into healthcare power of attorney, this allows another person to make healthcare related decisions, same language as before. The creator is the principal, the person receiving the power is the agent. Principal has to be 18 years old, of sound mind. What does sound mind mean? I, questioned at 4 o'clock in the morning when my daughter came in my room screaming. If I was of sound mind in the context of this, creating a power of attorney, the statute, the only guidance it gives is that it means no finding of incompetence. So if you're already under a guardianship, you can't do a power of attorney. Other than that, jury's out. That's why you get the question over whether they're valid or not. Usually, not always, power of attorney takes effect upon the finding of incapacity by either two physicians or a physician and psychologist. And actually, it's been expanded to include other healthcare professionals that are seeing people more often, like nurse practitioners and PAs, etc. They have to personally examine the principal and sign a statement that they have incapacity to make decisions. The statute is also clear that old age, eccentricity, or physical disability, either individually or taken as a whole, do not equal incapacity. So there actually has to be a showing that the person, for whatever reason, cannot make healthcare decisions in their own best interest. Agents' responsibilities are to act in good faith with and consistently with the individual's desires. So again, in talking about what does it mean to create this document, there needs to be a discussion, a two-way street between the principal and the agent of, okay, like what do I want to have happen to me? What does quality of life look like to me? What do I want for my care? And that would also include honoring a living will, or also called a declaration to physicians, advance directive. You probably heard all those terms about, do I want life support? Do I want feeding tubes? Do I want intravenous feeding? Do I want breathing machines? All those decisions. Healthcare power of attorney supersedes a living will. If there is no specific directive, or if the principal's desires are unknown, the healthcare agent in good faith needs to act in the principal's best interests. There is a line on healthcare powers of attorneys about making decisions when the principal is pregnant. Healthcare power of attorney, if necessary, can sign documents. Oftentimes, in addition to this, there's also a HIPAA release that comes along, making clear, the agent has access to the confidential health records. And the agent can even make an anatomical gift with permission from the principal. So it's really can be a lot of power. Just like the financial, it can be revoked by revocation in writing or verbal, destruction, or doing a new document. So creating a new healthcare power of attorney invalidates a prior one.
It looks like we have a question regarding
Okay.
healthcare powers of attorney. Wisconsin, for the example, it says Wisconsin can't activate until incompetent. Illinois can be active at time of signing. What if someone has one in both states? Which takes precedent? Would the immediately active only be active in that state, or can it cross state lines?
So you actually can draft a healthcare power of attorney to be effective immediately in Wisconsin. In terms of my answer to this question, and I'm not positive that I'm right, but if there were two, there's full faith and credit. So if you had a power of attorney done in Illinois and one done in Wisconsin, it wouldn't be which state trumps which, it's which one was done later. Because per our law, the one done later in time would be the controlling one. So I would not say to have two, different powers of attorney in different states with the expectation that they're both, active at the same time. And you can draft it so that it's effective immediately to give the agent power without the finding of incapacity. So that is an option. And that's why I said usually in terms of the language being that the person has to be found incapacitated. So very good questions.
So a Wisconsin one
Um,
can be activated as long as the person can be deemed incompetent,
no, you can
or
draft it at the outset saying like, I'm creating this healthcare power of attorney and I'm giving my agent authority
no.
immediately.
Okay.
But, and I have seen that done, but you that's a big step. You know, you're giving someone authority to make your healthcare decisions when you're ostensibly able to do it yourself. So I wouldn't say that I've seen it a lot, but it is possible. There are also people who go in and out of capacity to make decision making. And so I've seen some creative ones for people who, you know, sometimes might be able to do it on Monday and Tuesday they're not again, and Wednesday, you know, it goes in and out. So
Right.
it's possible you can do it, but generally the general language is the agent is only going to be making decisions for you if you are incapacitated to do it yourself. That's the
Okay.
norm.
Thank you.
POAs don't, like, for example, a financial POA doesn't give you, like, Social Security still is going to want you to be rep payee, and they still have their own paperwork that they want you to fill out. For educational decision making, POAs don't really cover those either. So that, I think that's an example of a way supported decision making and powers of attorney can work together. Supported decision making agreement could deal with the educational decision making, and powers of attorney can cover, you know, all the things that they cover. So with that, the next, we're going to shift to guardianship. So if anybody wants to talk about either POAs or supported decision making or how they work together, now is a good time to ask, or otherwise we can move into the G word. Okay, I am not seeing any new chats, so feel free to jump in. So guardianship, and we've got the picture of the courtroom here because you can't get a guardianship without going to court. So for all guardianships, no matter what, for adults anyway, the person has to be at least 17 years and 9 months old when the guardianship is entered. And the individual's need for assistance in decision-making or communication is unable to be met effectively and less restrictively through appropriate and reasonably available training, education, support services, healthcare, assistive devices, or other means that the individual will accept. So that's not how I talk. That's directly from the statute. But I bolded there the unable to be met effectively and less restrictively, because guardianship should always be considered the, you know, the most restrictive option. If there's any way for the person to either get by without it or to have a less restrictive guardianship, that is what the preference is supposed to be. I think in real life, that's not necessarily followed. I think guardianship is used more than it needs to be. I think guardianships are more restrictive than they need to be. I think that's kind of the default. I think a lot of times if you ask for one, you're going to get one. However, the concept of least restrictive, which some of you may be familiar with from other areas, especially special education, is there. Let me see, there's a chat. If you're rep payee, does that end when the person turns 18? It does if the minor has Social Security, and then you have to redo it as an adult. Oh, I've also highlighted that the individual will accept. So that's another reason why sometimes guardianship becomes necessary over the less restrictive forms, is that if the person is refusing assistance, then the fact that the assistance could technically help them becomes irrelevant. If they're refusing it, then that can show a need for guardianship. So we're going to talk about guardianship of the person. It is court ordered. The guardian of the person exercises some rights, makes important decisions, does not make financial decisions unless they're also the guardian of the estate. Some key terms are the petitioner, that is the person who is asking for the guardianship. If we're talking about our children here, oftentimes the petitioner is either going to be the parents themselves or the county of residence, sometimes through their Aging and Disability Resource Center petitions for guardianship. The guardian or proposed guardian is the person who will be the decision maker if the court approves, and then the ward or proposed ward is the person who's under guardianship. Ward is the legal term, it's in the statutes. I try to use the term individual when I'm talking, when I'm not quoting the law, but that the term ward is out there. That's still a legal term. So in terms of evidence, so I don't know if you got them before, if you'll get them after, but I do have some handouts. One of the things is the blank examiner report. So you can take a look at what goes into the court's determination of whether or not a person, medically or psychologically meets the standards for guardianship. So either a physician or a psychologist or both have to examine the ward. There's a statement of rights that needs to be read prior to the examination. So the person is clear, like, hey, if you sit for this exam, it's going to be used probably against you in a guardianship proceeding, and the questions that you're answering or not answering, I'm going to use that to tell a court whether you need a guardian or not. It answers questions about the person's disability, what their needs are, whether they meet the standards for guardianship, whether the examiner thinks they have the capacity to exercise certain rights or make certain decisions. And it also addresses the need for protective placement, which is kind of a step above guardianship if someone is court ordered into a facility.
So because Victoria get it at 17 and 9 months, so if it's granted at that point, when they turn 18, it continues, correct?
It does, yes. If they have a minor guardianship that's based on, not on disability, but like for whatever reason, somebody other than the parents is their decision maker, that does not continue. So let's say we have a child with autism who's under guardianship, like grandma's the legal guardian because mom and dad aren't around. Okay, just for example. Grandma, when that child turns 18, still has to get adult guardianship. Doesn't matter that she's the minor guardian. However, if the question is, if you get it at 17 and 9 months, do you have to go back when they're 18? No, that goes through to adulthood, and it's the one nice thing at transition time that you can get done before the person turns 18.
Okay.
Okay. So the standard to get a guardian of the person is that because of an impairment, the person is unable to receive or evaluate information or make or communicate decisions to such an extent that they cannot meet the essential requirements of their health or safety. Again, this is straight from the statute. And you can see kind of the language there is going back to a supported decision-making agreement, going back to what is an informed decision. That is the root of this, is are we able to make informed decisions? So in a guardianship of the person, there are kind of 3 buckets of rights. The first set refers to some of our most fundamental civil rights, and the person either keeps them or loses them in full. So the individual can't exercise these rights and nobody's exercising them on their behalf. The next set is rights that either can be removed or exercised with guardian consent. The individual can do this if the guardian says it's okay. And then finally, there are rights that can get transferred to the guardian either in full or in part. And we're going to go into what those are. So the civil rights, the big buckets that are removed and not transferred are serving on a jury, executing a will, and voting in an election. So if I'm under guardianship, I don't have my right to vote. and my mom's my guardian, she can't go vote for me. It's just gone. She can't sit on a jury for me. She can't do a will for me. Those rights are just lost. The next set of rights are consenting to sterilization, marriage, bone marrow, organ, or tissue donation, and then application for licenses, which include hunting and fishing, driving, and professional licenses. So these are things that either the person can retain, they can retain with guardian consent, or they could be removed in full, meaning the guardian couldn't consent on the individual's behalf for those things, even if the guardian wanted to. And then finally, the rights that can be transferred. Those include healthcare decisions such as choosing treatment providers, participating in research or experimental treatment, and release of healthcare records and other confidential records. Choosing social services, both enrolling in programs and choosing providers, making educational decisions, both for in the IEP context, but post-secondary, employment decisions, working with DVR, deciding whether or not the person will work, which can be a big decision when you're balancing public benefits. Applying for a protected placement, which is, does the person need to be in some kind of facility, assisted living or group home or nursing home in certain cases. Advocacy for the person in court proceedings, so not contracts or money, but the person get into some trouble, the guardian can appear for them in muni court or in criminal court and say, hey, this person is incompetent, they're not able to make their own decisions, they're able to speak on their behalf. Receiving notices, so mail, or you get notice of a court proceeding that goes to the guardian instead of the individual. Making decisions about terminating a marriage, so divorce. So either they're already married or they've retained the right to marry with guardian consent, they should retain the right to end that marriage. And mobility and travel. So where are you going, when, with who? These are all things that can be transferred to a guardian. Guardianship can also be full or limited. So in a full guardianship, everything that can be removed is removed. Everything that can be transferred is transferred. The person, is basically totally incapable of making any decisions on their own. In a limited guardianship, the person may retain some rights. They may be given specific input into decision making, and the guardian's authority may be limited. So some of these things that we covered, a big one is people maintaining their right to vote. And I'll just put in my little plug, the right to vote is way over removed. One of the things we were talking earlier about transition is on your IEP, in your post-secondary transition plan, there's the spot to say, we're going to work on civic duties. And I think almost every kiddo should have that. So we don't get to this time and say like, oh, I don't know if they can do it. Disability Rights Wisconsin is launching, has launched, is operating a project right now for people to keep their right to vote when they're going through the guardianship process, and to restore their right to vote if it's already been removed. So think a lot about that as you're going through this process, because that's something that makes us who we are as citizens and should be retained whenever possible. There's also guardianship of the estate. So depending where you live, Waukesha and Milwaukee counties are more prone to avoid guardianship of the estate when the person doesn't have a lot of assets. And by a lot of assets, I mean 50,000 or less in Waukesha, 10,000 or less in Milwaukee. Other counties require guardianship of the estate, so I won't get too much into that, but it depends where you live. For guardian of the estate, the person's impairment has to impact receiving or evaluating information or making or communicating decisions related to their property management or their financial affairs to such an extent that either they can't support themselves, they can't prevent financial exploitation, or their property will be, dissipated, so like wasted, lost, however you want to say, in whole or part. So that is the standard, and it is not an 18-year-old buys concert tickets instead of, I don't know, something more responsible. It's not you spend you go to Quick Trip every day after school and waste money on snacks. It's not that kind of, bad financial decision making that a lot of kids, teenagers make. That alone isn't going to be sufficient. I don't think for guardianship. It has to be like, I don't understand money. I don't understand that I have obligations every month. I don't understand that the roof over my head is a result of somebody paying for it. These are global concepts of ability to manage money, know what it's for, and support oneself. The guardian of the estate provides financial support for the ward out of the ward's income and assets. It doesn't mean that you are responsible to spend your own money on the individual. Enter into contracts, settle claims. There's often, not always, a responsibility to provide an annual accounting to the court. And that is a good thing because there's accountability then. It doesn't mean that guardians never take advantage of people, but it's at least a way to try to stop it and, prevent that from happening. So there
Quick question, Victoria.
Yeah.
So you said guardianship of the estate is not as common unless you have substantial assets in Waukesha and Milwaukee. So does that mean those folks might have representative payees, or you'd recommend a financial power of attorney in order to help support the person with those financial decisions?
Sure. That's a good question. So you're probably gonna have a rep payee regardless if the person has Social Security or even if they're under guardianship or not. So what we do and what other petitioning attorneys do, counties do, is give the guardian of the person some of the rights of a guardian of the estate. There's also something called the alternative to guardianship for small estates that allows the guardian of the person to manage small amounts of money. And by small, I mean under those limits that I mentioned earlier. And that's really nice for people. So a lot of young people get Social Security, either SSI or disability, but they work. So they have income from employment, or maybe they have income from, grandma gives them gift money every holiday, or maybe they get in a small car accident and have, some money that has to be spent. The alternative to guardianship allows that. And then there are other things that are guardian of the estate powers because they involve contracting and legally binding someone in a financial concept. So that would include filing taxes, signing a contract like for an internet or cell phone, a rental agreement, housing, like a residential services agreement, creating an ABLE account, setting up a special needs trust. I'm trying to think what other powers we put in. So when you're going through that process, make sure that if you're not going to be the guardian of the estate, that you have the power to make those decisions. So the counties that require the guardianship of the estate, like require both, their philosophy is you cannot do your job as guardian of the person without also having those guardian of the estate powers. Oh, I know the one that I missed, and it's huge, is applying for public benefits and recertifying your public benefits. Believe it or not, even though it's a healthcare, you would think that's, hey, that's healthcare and social services. The guardian of the person would do that. It's actually a guardian of the estate job, unless the order is, you know what I'm saying, where the guardian of the person has the power to do that. So, does that answer your question?
It does.
Okay.
Thank you.
Okay, so there can be a lot of folks in the room, in a courtroom, when guardianship is being entered. So for every guardianship, there is a guardian ad litem appointed. That is an attorney who represents the individual's best interest. And it's their job to meet with them, advise them of their rights, interview the guardian or proposed guardian, and make recommendations to the court about whether the guardianship is in their best interest, whether it's appropriately, you know, restrictive or not restrictive. They can ask for an independent evaluation. They can ask for an attorney to be appointed for the proposed award. If they object, they can say, hey, I don't think this guardian is appropriate. If there is an objection, an attorney is appointed for the individual, which is called advocate counsel or adversary counsel. And their job is to advocate for what the ward wants. If they don't want a guardianship, that's what they fight for. If they want a different guardian, they fight for that. If they say, hey, fine, I need a guardian, but I want to keep certain rights, that's what they fight for. They are calling witnesses. They can get an independent psychological or medical evaluation. They're going to represent what their client wants in court. And that's not their client's best interest, it's what their client wants. And then it is required for a guardianship that the county get notice both through their attorney and if the person receives benefits through the Department of Health and Human Services. So the county may be a participant in a guardianship hearing. If they petition, then they obviously will be, but they may be regardless. So you will get copies of the slides. So I have some resources. One is the Marquette Volunteer Legal Clinic. They don't provide ongoing legal assistance. They won't go to court with you, but if somebody is thinking about doing a guardianship on their own, I would highly recommend setting up an appointment with the legal clinic. It can all be done virtually. You do need to have a doctor or psychologist report already done when you sign up, but they help people get all their forms in order, and it's really helpful. I've also got some links here for all the different options. There's a guardianship support center. They have really great resources, as well as a newsletter that gives guardians all kinds of information. There's supported decision-making, advanced directives, so healthcare and financial powers of attorney. The forms, you can get them on the internet, print them off. Not saying you shouldn't consult with legal counsel, but you know, you don't have to. They're available online. The link is there. And the ARC of Wisconsin and BPDD here in Wisconsin they're the go-tos on supported decision-making. They were highly, you know, they were instrumental in developing the law. So they have really great resources as well. I've got my contact information here. Feel free to call me, shoot me an email. Our office is in Milwaukee on the river. It's like right on the border of downtown on the east side. But I go all over the place. I'm from Pewaukee. I'm in court in Waukesha every week, sometimes every day. So Waukesha is home for me, but practice in Milwaukee and Waukesha the most. All the surrounding counties, and especially for special education law, I'm going all over the place, the whole state. And with that, do we have any questions? I see.
Yeah,
a
we
new
had,
one
I
here.
want to start with just one question we had earlier real quick, just so I don't forget.
Sure.
You might have answered it. They were asking about representative payees. Does it end when a person turns 18? I'm guessing they're the representative payee of a child, would be
It
my
does,
guess.
like
And would that,
you have to reapply, if they have it as a child, then you have to reestablish it as an adult. Yep.
okay, thank you. And then the next new chat, please speak to healthcare participation in care forms. Many healthcare providers don't seem to know what they are. Is there is there other language we can use to request the form? Is there a generic state form to use, or is the form different for each provider? These are super handy when a young adult, for example, is going through cancer treatment and is just feeling too awful to deal with all the details of their care. Or a young adult who is not under guardianship but can't effectively manage their own care, like making appointments, prescriptions, getting information about complex medical issues. Is there another name for this type of document that we should be using when making a request?
Okay. So I don't know, like the participation in care form. I don't know about that. I mean, what I would say this situation is a supported decision-making agreement paired with a release authorization that would be specific to the provider. And that's kind of an unfortunate thing is you have to sign those with the individual provider. A lot of times you have to redo them every year or at other intervals. But in a situation, I think cancer is a good example where, some days like they can make decisions very independently. Otherwise, others they require a lot of support. I think that's a perfect supported decision making plus healthcare power of attorney situation where if they really get to the point where like, look, they just can't for whatever reason, then the agent's authority kicks in. And look, once a power of attorney is activated, it doesn't have to stay activated forever. It can get unactivated just the same way as it got activated to begin with. So I hope that answers the question. Then I see another question about jury duty.
So if someone doesn't have guardianship and they get called to jury duty, but probably really don't have the capacity or ability to do the jury duty, what do you do if you don't think they could effectively be on a jury?
I don't So what I want to say is you probably show up and explain that they wouldn't be able to serve jury duty for medical or psychological or whatever reasons. But I'm assuming, and this is just, I don't know the answer to that. I'm assuming there's a better and less intrusive way to do that other than actually showing up for jury duty. I don't know the answer to what that is, but without guardianship, there would have to be some active communication as to why they couldn't participate. You couldn't just not show up. Sorry, I don't have more detail for that, but guardianship would be the only, and that I believe the guardianship takes the person off the rolls of, because they select people for jury duty based off rosters and then you're not on it if you're under legal guardianship. But yeah, that could be an interesting situation.
Um, is there another name for the participation in care form? So is that
Yeah, and
really, go ahead.
I don't know what that's referring to, participation in care. I mean, I'm guessing there's some form out there that's saying like I want so and so to be able to participate in my care. That like it has to be at the end of the day some type of HIPAA release where you're authorizing somebody who otherwise wouldn't have access to your doctor, to your records, to whatever confidential information to have it. So I would just say HIPAA forms
Right, because
and
the
see
HIPAA
what
release
gets
would at least allow you to communicate correct with the doctors, know what medications are on, what was discussed, request documentation of what happened at the visit,
get on
post-care
get on the My Chart
recommendations.
or the
And
Epic,
then,
get on
of
the electronic medical records, send messages, once you're in there,
Right.
I don't want to say that's everything, but you get that access and you're able to do a lot on behalf of your person.
And you're allowed to attend an appointment as long as that individual during the appointment's like, yes, I want this person to come
Yep.
on back with me.
Yes, absolutely.
Okay. Assuming that's what they want.
Yeah. But I
Okay.
think if you have issues with that for whatever reason, that would be a
Right.
reason to get a supported decision-making agreement in place.
Right. And you said that might be a good reason also for the healthcare power of attorney, because I thought you had mentioned there might be a case where on Monday someone's not able to because maybe their condition. I think that's kind of where, the mention of that cancer one, right? Like today you're doing good, tomorrow you're not, so you're not able to manage your healthcare decisions, but in a few days you're feeling better and you're more able to do things
Yep.
where it can be more intermittent. And so maybe that might be a case of working with an attorney to get healthcare power of attorney paperwork that is very specific to the current situation and what's
Yep.
happening.
Absolutely.
Okay. And then I just have a question. So a guardian can be a representative payee, correct? As long as it's not like I know I'm a volunteer guardian and I can't be a representative payee for my people, but that's different because I'm not like their family. But in general, you can be a guardian of the person and be the representative payee, correct?
Correct.
Okay.
Yes.
Is there ever a reason why you would recommend for those two duties to be separate?
Well, one is if the person, like, for what sometimes people have things in their history where like they're a good healthcare, personal decision maker, but managing money is just not their thing. So I know plenty of people, actually, I mean, even without any issue on the guardian's financial management, who have an agency, so they're like rep payee agencies that serve in that role. And sometimes it's as simple as the parent doesn't want to deal with it, or the guardian, it's just not there. They don't want to manage an extra bank account.
Right.
Um, and when you have an agency, they're subject to all these reporting requirements. There are definitely pros to having an agency. Also, another example is
Because you can have the
divorce.
agency just manage the Social Security, and then you
Mhm.
can manage the ABLE account or trust or
Sure. Yeah, you can
whatever.
do that. You can do that. Absolutely. Sometimes rep payees do manage the other, like income from employment, like the agencies, I mean. And another reason is if you have a situation like, for example, with divorced parents, or you have adult siblings that are caring for their, their sibling. Maybe you're just splitting duties. And again, it's not because it's more of a convenience matter or a skill set matter. But I see that a lot where, one sister has finance, one sister has personal, or mom and dad split things up that way. And, you absolutely don't have to have the same person in all the roles. I see the same thing actually for healthcare and financial power of attorney, including like when people are naming their adult children, they have one for finance, one for personal, and it's just because of skill sets and interest and ability and all of that.
And then I guess I wanted just to ask, just because I think this is really thinking long term for some of our folks, is successor guardians.
Sure.
Is, kind of what kind of layers or what should families be considering when thinking about successor guardians? Because, like, what if you are a parent and this is your only child, and what kind of things should you be keeping in mind? Because I know the alternatives, I've had this, again, I'm a guardian for people, so
Mhm.
who obviously don't have family and have no one, and no one prepared for a successor guardian, what should people consider?
Sure. So I always, when I'm petitioned, recommend people to name standby guardians that would be effective if they got hit by a bus tomorrow. So a lot of times people want to name their other children who might be 18, 19, 20, and you have to ask the question, you know, okay, if something happened to me next week, is A, can they do it? And B, do I want them to do it? Is that, I don't want to say is that fair, but are you asking a child effectively to be the guardian for another child? So I usually recommend, when appropriate, like multi-generational planning. So, and also trying to do someone at the same generation as the guardian or less, and then one below that, to try to avoid a situation where there's nobody, you end up with a corporate guardian, or, you know, no offense, volunteer guardian, where it ends up being, I mean, and I know there are volunteer guardians that are amazing, and there are volunteer guardians who are not amazing, and at the end of the day, it's a stranger, right? So you're working with families that are planning not just for the rest of their life, but for the rest of their child's life, and how do we take care of that? So yeah, I would say, and there's no limit. You can name the most I think I've seen is 4 like successors in for guardianship. I think for powers of attorney, the most I've seen is 3. But you can have multiple options. And here's the other thing, the order doesn't really matter that much. So let's say you name your sister, who's roughly, you know, again, your generation, and then your adult child, and 15 years pass before something happens to you. Well, maybe even though your adult child is now 35 instead of 20, it's still not a good time, because she's got a 3-year-old and a 1-year-old, and she can't do it right now. You know, it just gives you that flexibility to make sure that whoever is stepping into the role is really able to do it, because I don't want to say it's a full-time job, but
It's a
some
commitment.
weeks, I mean, it's a commitment. And I bet you, like, in your experience, would you say there are weeks you've put in 20 or 30 hours?
Yep, absolutely. And it's midnight and 3 in the morning, and
Mhm.
absolutely.
Yep, and holidays, and yep.
Yep.
So yeah, it's not a small undertaking. And here's the other thing I'll say. Being a parent and loving someone does not necessarily make you a good guardian, or that you have the skills, let me put it that way, to be a guardian. It's a skill set. Now, for many parents who have taken care of a kid with special needs for their whole life and dealt with the healthcare system and dealt with all this stuff, yeah, they are the best person and they know that kid the best, and like hands down. But I have parents who have chosen other family guardians, chosen corporate guardians, because that's the best thing for their family. So at the end of the day, it's not about love or care. It's about
Yep.
being in the trenches, making the decisions day in and day out. And like, do you have the skill set for it? Do you have the time for it? Do you have the energy for it?
Yep.
And it's
I've
okay.
actually seen
No.
families who live, I'm a guardian for someone who lives, the family actually lives in another state.
Sure.
So there's no one even here to be like, yeah, you
Yeah.
can be a guardian in another state, but if you're not really seeing what's going on in present, it makes it very difficult.
Oh, for sure.
Um, One question we got, the Wisconsin generic healthcare power of attorney form has a line about not being able to put someone in a nursing home due to mental health issues. What do families do when they have a family member with longstanding mental health condition and they become elderly and need long-term care?
Sure. So, yes, powers of attorney don't let you commit someone for mental health. So, I'm going to answer your question 2 ways. One is, oftentimes we see people who have struggled with a mental health disorder for their whole adult life, and then they, in old age, develop a degenerative brain disorder that, taken in conjunction with the mental illness, makes their ability to care for them. I mean, those are some of the most serious cases that I see, quite frankly. And if you have the non-mental health reason for the guardian, well, for the placement in your question, you can get that. There's also one of the categories for guardianship is serious and persistent mental illness. So you can, if it's, again, long-standing, I don't want to say untreatable, but hasn't improved with treatment for years and years and years, you can get a guardianship and a protective placement based on that. You were talking though about power of attorney. So in that situation where someone's not incompetent, but their mental health, their treatable mental health issue is impeding their ability to care for themselves, that's a Chapter 51 mental health commitment that's either done through law enforcement, or, you know, similar filing it, or what's called a 3-party petition. We could have another whole huge thing on that issue. But mental health treatment, I mean, not just commitment, but treatment in general is treated differently under powers of attorney and guardianship law.
Power of attorney could put them into a nursing home if it relates to their being the elderly side of it. Like, I can no longer care for myself and live here. If you're entering the nursing home because of inability to physically care for yourself and you have physical health issues now, that's okay, as long as the admitting issue is not the mental health, correct?
Well, and that you're admitting into like long-term care facility versus a mental health institution. Does that make sense?
Yeah, so they're going into
So
a true nursing home.
yeah, there are plenty of people in assisted living and, you know, CBRFs, nursing homes that do have a mental health issue, but that's not why they're there. They're there because they need the nursing support or they need the supervision or what have you. And there's a line, so there's actually 2 lines that I think kind of got, you know, merged into one. The principal has to choose on the form whether their agent can admit them into a nursing home or not. And if they say no, then they can only do it for a short, like, respite or recuperative period of, I believe it's 30 days. Now, many people don't want to go into a nursing home. So if they have a power of attorney and it says no, but they need that level of care, then you're at guardianship. Do you know what I mean? Like, if they're refusing nursing home treatment, then what ends up happening is somebody files a guardianship and a protective placement, and they end up being court ordered to usually a nursing home or sometimes like a larger assisted living facility or memory care unit, for example. So it's 2 different lines on there. One is mental health treatment. Another is, can the agent admit me? I usually recommend to say that the agent can admit, even if the whole family's goal is like, you'll never go into a facility, we'll take care of you at home, because otherwise you end up, even though you did your advanced planning, you end up with a guardianship. At the end of the day, a person who's in a nursing home and doesn't want to be there always has the right to object, always has the right to ask the court to move them. They never lose that. But from a planning purpose, the document, I feel, should give the agent the authority to make that decision. But that's me. So.
Right. Great. Any other questions? I don't see any. So I'm just going to wrap it up then. I just want to say thank you, Victoria. Thank you, everyone, for participating in our webinar tonight. We have another one in June about the telecommunication equipment purchase program, which is available for people with hearing loss. So you do not need a cognitive disability to get that. Physical, you can have a physical disability. So register for that on our website like you guys always do. I hope it's been helpful, and I will send everyone the follow-up email and information that Victoria has provided. So thank you, everybody.
Thanks,
Have a good night.
everyone. Have a good night. Thanks for having me.
Thanks. Bye.
Bye.